Judgment in the matter of the Queen on the application of DA and DS and others versus Secretary of State for Work and Pensions.
Lord Wilson will explain the decision of the court.
These two appeals represent a challenge to the legislation which introduced what is called the Revised Benefit Cap. It is the Welfare Reform and Work Act 2016. It provides that where families receive state benefits of a specified character of more than £23,000 a year if living in London, or £20,000 a year elsewhere, the benefits should, subject to various ways of escaping from it, be capped at those levels. This legislation is tough. One of the ways of escaping from the cap is for the adults in the family to go out to work. A lone parent must do so for 16 hours a week, and a couple for 24 hours a week in all. The main object of the cap is indeed to persuade adults in receipt of benefits to go out to work, which the government believes, perhaps correctly, to be better for the whole family in the long run. These appeals are brought by 5 lone parents, all women, and 11 of their children, 5 of whom were under school age when the cases began. So the focus of the challenge is the effect of the cap on lone parents with children under school age. And the argument is that the cap discriminates against such families because of the particular difficulty which confronts lone parents of young children in going out to work and thereby enabling the family to escape from it. The suggested legal basis of the challenge is the Human Rights Act 1998. The appellants say that the cap discriminates against their type of families in the way in which it affects the enjoyment of their right to respect for their family life under Article 8 of the Convention on Human Rights. So they ask the court to declare to Parliament that the cap is incompatible with their human rights. It has taken the 7 of us 10 months to deliver today's judgments. By normal standards, we have been far too slow. But the delay shows how difficult we have all found the decision to be. In the event, 5 of us, including myself, have decided that the appeals should be dismissed. But Lady Hale and Lord Kerr would have allowed the appeals and have made the requested declaration. And let me be the first to concede that readers will find their dissenting judgments powerful. We've had to weigh up a mass of evidence. It persuades us all that the cap has had a major impact on lone parents with children under school age because it is particularly difficult for them to go out to work. And that, although it is sometimes offset by other benefits which can be made to them instead, the effect of the cap on them, and particularly on their children, is often harsh. The law of discrimination in relation to human rights is complex. Discrimination is, for example, only unlawful if it is on the grounds of a person's status. My 4 colleagues who join me in the majority are more doubtful than I am that the various groups of these appellants all have the required status. But the question which really divides the court is this. When we have to decide whether this rather brutal application of the cap to these families is legally justified, how much leeway do we have to afford to the fact that the refusal to exempt them from the cap reflects a deliberate decision of social and economic policy taken by the government and by Parliament, which, unlike judges, carry democratic authority. The majority of us, including myself, although here I am departing from an earlier view, hold that the law affords the necessary leeway by requiring us to ask whether the application of the cap to the appellants is manifestly without reasonable foundation. We agree, importantly, that whether it has a reasonable foundation may well depend, among other things, on whether the government has treated the best interests of the children as a primary consideration in accordance with its duty under the UN Convention on the Rights of the Child. We consider, however, that we cannot go so far as to say that this application of the cap is manifestly without reasonable foundation. We, the majority, therefore conclude that the appeals must fail.